Okay. Hopefully you can all see the slider, and hopefully you can tell me if there's a problem. Right, so you can see from the title, Minority Case Law Challenging the Limits of Law. And the very purpose of the presentation is to find out how we can recognize the rights of asylum seekers and refugees within the ambits of the law, and find ways and processes, mechanisms that can broaden the scope of evidence so that the voice of minorities in the UK, including asylum seekers and refugees, can be heard more. Now, just to put this into context, and as Anna said, the work that I do is I have a consultancy called Diverse Legal Consulting, and by grace of God, over the last 3 years, I have been writing a lot of country expert reports for asylum seekers from the Middle Eastern and North African region. And yes, by grace of God, I received an award, but that's not important. What is important is the work that I'm doing is very much focused on writing a report to analyze the threat of persecution in a region. And a number of the countries are Muslim countries, some are non-Muslim, it doesn't matter. But the point is that when I'm writing the report, that report in saying, for example, let's say that ISIS is there in Iraq, or for example, certain human rights are not recognized in Middle Eastern and North African countries, or somebody's culture is under threat, or somebody gets divorced and then they're stigmatized from their community or ostracized from the community. When I'm writing about these issues, my report gets submitted to the Immigration Tribunal. Now, that report forms part of the immigration case, part of the case of a barrister that's representing the asylum seeker. Now, the issue is this, that I'll turn off my PowerPoint actually for a bit so we can have a bit more interaction. The problem is this, that my report or another country expert reports that's submitted only forms one component as part of the whole case. So you have witness statements, you have other pieces of evidence, you have the barrister's arguments, the skeleton arguments, etc. So now the judge has to make a decision on whether to grant an asylum seeker who's fleeing persecution a right to stay in this country or not. That's the judge's task, right? Now, what evidence is he going on by? Well, he's going or resting his judgment upon the barrister's argument, upon my report, upon the witness statement. And so, fine, you might think, okay, well, this is a highly evidentially prepared case. And yes, the problem, however, is, and this is what I've noticed in the last 3 years, when it comes to very nuanced issues to do with religion, sects, theological doctrines, jurisprudential doctrines, sectarian conflict, more cultural issues, let's say like divorce or language or tribal mentalities, the UK immigration system, and I do commend the fact that it exists because other countries don't have such a system. The problems are that the judge and the barrister or the solicitor do not fully understand these nuanced issues. So as I was talking to Ryan today, just in a small conversation we had, that maybe in the United Kingdom, when somebody gets divorced, just as an example, the level of stigma isn't as high as it would be, let's say, in a Pakistani or Indian society, right? Or in a Malaysian society. Or, for example, the fact that we can form political parties, whether right-wing or left-wing, and express our views, and yes, there can be backlashes in the UK, fine. But if you were to do that in Egypt, and you were part of the Muslim Brotherhood, you would be politically repressed by the government, right? Now, a judge that receives an asylum seeker's case and says, if it's a woman, let's say, and she's divorced, and then is being ostracized, let's say, by a community or the family in a such way, or, for example, if you're talking about a political party that's fighting for some democratic rights, but ultimately is not recognized as such in their own country, and a judge says, well, I'm dismissing your case because your constitution says that you can form political parties and you do have freedom of expression. Well, constitutionally may be guaranteed, but de facto or in practice, that is not the case, right? There is political repression. So the question now is, how is a judge or a barrister going to recognize the rights of an asylum seeker in a holistic manner, appreciating the religion and the theology and the cultural factors that are, I would say, the main parts of his asylum case? So far, have I been clear, everybody? Please tell me yes or no. Have I explained the problem question? Yes? Yes? Okay, good. Anna's saying yes. Okay. So, in a way, you're all observing me because this is how I would teach in class and explaining our formative and summative coursework, right? So, hopefully, I've been clear, all right? Okay. So, now, well, what's this got to do with me and what's this got to do with my research? So, now I can go back to the PowerPoint. And I dislike using PowerPoint. I like more traditional teaching, but let's go for it anyway, okay? So, this is my humble solution that you can see on the slide in front of you. It's called Minority Case Law, but I may change the title, but at least for this purpose, I can explain it. It's case law that is produced from minority communities themselves and works alongside the national legal system to improve judicial decision-making, access to justice, which is one of the main purposes of CAJI, the Center for Access to Justice and Inclusion, and help realize the rights of those in the margins of society. And I've said such a notion does not exist, but comparable notions are religious tribunals, historical legal, pluralism, national EU and international law case law. So what this means is that, as you all know, and a number of you are lawyers, is that we have national case law, right? We know that the Supreme Court can make a decision on cases, the Court of Appeal, the High Court, etc., right? So we have this national case law, which is wonderful, right? That is the example of the Wednesbury principle, or the executive, legislature, and judiciary, working with each other or having a checks and balance with each other. The problem is, this is my humble argument, there is a gap or a lacuna within the law when it comes to internally within that case law process recognizing the rights and voices of minority communities. So what I'm suggesting is that how can we give a voice for minority communities, whether they're asylum seekers coming to the UK, or I put here the last bullet point, Muslims in the UK, right, suffering from Islamophobia, right, a woman that is observing hijab or wearing scarf, for example, and perhaps is subjected to some physical or verbal abuse or some discrimination, maybe even by the British legal and political system. And this is not just exclusive to Muslims, it could be or any other minority, right? And what I'm suggesting is, alongside the national case law, right, I'm suggesting that two things. We broaden the notion of evidence so that the evidence that is presented about somebody suffering discrimination or somebody coming to the country as an asylum seeker and saying, I'm stigmatized because I'm a divorcee, any of these things, perhaps we can broaden the notion of evidence so that the evidence doesn't just come from one person, a barrister or solicitor, but comes from the community, right? And let me just go to the relevant slide before I explain case law, and I put it here. The definition of evidence, according to Osborne's Concise Law Dictionary, is the means exclusive of mere argument which tend to prove or disprove any matter of fact, the truth of which is submitted to judicial investigation. It may be oral, it may be documentary, conclusive, direct, circumstantial, real, extrinsic. I've highlighted that, something external to the general case law process. Hearsay, indirect, original, derivative, oral, prima facie, primary, secondary. So first of all, I think one, if you like, theoretical starting point, or those of you interested in jurisprudence, is that UK English law recognizes the expansive nature of evidence. And I think that's a beautiful part of our legal system, that you can have evidence that is not submitted just by a legal representative, but coming from the person themselves, or coming even from beyond the initial case, if you like, but which is able to be proved or disproved and can be investigated judicially, right? So that's just keep that in your mind, right? So how are we going to create this voice from minorities? Well, I've come up with this term called communal evidence, right? Extrinsic means that as to the meaning of a document not contained in the document itself. So it doesn't have to be on a piece of paper, though it can be recorded in a piece of paper. And primary is something, original documentary on the subject. Now, what I have observed so far, not just, I was born in the UK, but somebody coming from a multi, religious and if you like, racial background, and roots are Indian, I'm Muslim, I'm British. What I've noticed is that when minorities are suffering problems, whether it's Islamophobia or an asylum seeker fleeing persecution, the problem is, how are they going to express their evidence? They're going to use a witness statement, fine. They're going to say to a barrister, they're going to go for a Home Office interview, and the Home Office interview, by the way, is translated, right? So, or there's going to be an interpreter there. So basically, their fears about what they're going through may get lost in translation, one, and two, may not be expressed in the way that they want it to be expressed, and three, some of the terminologies that are used are not always understood. So I gave the example of hijab, for example, the holistic meaning of that, or divorce, known in Arabic as talaq, a very serious thing, at least within Islam. Or three, for example, whether you're dealing, I would say, with more socio-political factors, let's say an identity document or an identity card in Iraq, and the fact that if the identity card is not there, then somebody that's removed back to their country, like an asylum seeker, will struggle to find a job and housing because they don't have an identity card, because either they've lost it, or on fleeing, somebody took it from them, right? And then the Home Office says, well, you can go back to your country because you know the language, you've lived there for 20 years, but your village is bombed. You have no identity document. Your family is dead, for example, or the political party is hunting you. So when the Home Office says, well, you can be removed to your country of origin, these nuances need to be understood, right? So what I am suggesting is, if we can, as a first step, right, create evidence that comes from a community. And if you have, for example, Iraqi communities or Indian communities, or an asylum seeker that comes and becomes part of a community or then becomes a refugee, that community should be able to express some very common threats of persecution that they have faced, which are real and substantiated, and two, they can express it in their own manner, but this can be presented as what I've termed here as communal evidence, right, to the judge. So it's not just the barrister presenting it. It's not just the judge looking at it as a secondary evidence, or another person's interpretation of what hijab is, but something that can be presented from the community itself, right? It's like, my wife, when she observes scarf, fine. I know that this country is a generally respectful country, right? But I know sometimes other countries in the world are not as respectful to minorities, right? But the point is, my wife's experiences is not something that's always going to be appreciated by people external, right, outside to the immediate community, whether she gets some kind of looks, whether it's discrimination in terms of a job. All these things are there. Now, if these things can be documented and recorded, then it bolsters the voice of a minority community to say, well, our rights aren't necessarily being upheld. And that's not to say that whatever they are saying is true, but it can be proved or disproved, as I gave the evidence, the definition just now. But at least it's presented in a strong way, coming from more than one person. You may ask, well, how will this process work, and how will it form? How does it form case law, right, or minority case law? So I have done a procedure here. Now I have some slides on jurisprudence. I'll come back to that, but let me just present the idea so you get the gist of what I'm saying, right? Just follow these steps. See if these make sense. Again, this is it's an idea that is being developed. So an asylum seeker goes to the community scholar or expert, right? So you might have the president of the community, you might have a scholar there, you might have some representative of the community, and makes this claim, saying, look, Iraqi community or Indian community, whatever community, they go to someone that is known as a leader or scholar of the community and makes his claim. The community experts take a witness statement and interview records. So these could be the trustees, these could be people there's a committee that deals with this, for example. So you have people who are interested in the community that would take interest in the case. And my experience so far of Muslim communities, just as an example, is there usually are a few people that want to do charitable work. There is a committee of propagation, and you can go to these committees and explain your case. They further clarify terminologies, religious laws, community customs, and country information through their own experiences and primary source data. This data may be in the original country language. And I think this is very important. So what happens is, when this claim is made by the asylum seeker, there is also a kind of shared information that takes place. That yes, a fellow community member or the representative may say, yes, this has happened to me, or this has not happened to me, right? At least there is some recording of what is going on, sharing of data, and using original linguistic terms to express, what has happened to that asylum seeker. But in order to make the process objective, I've said a qualified English or European lawyer, because I think that this could be replicated for other parts of Europe. A qualified English or other lawyer or legal representative may preside over this appointment. So in order to make things objective, there should be somebody external from the community, right, that should sit in on this proceeding to see whether there is bias, whether there is any politicking going on, whatever is going on, so that there is some sense, I would say, of transparency in the proceeding. Okay. Then what happens is the community experts submit this information to solicitors who are qualified to represent the asylum seeker. So that's why I said that what I'm proposing is not against the English legal system, but is to work alongside the English legal system, right? Because I think, I think this is a very simplistic thing, but I think it should be addressed. I think that there are fears in UK and in Europe, sadly, I feel, that, whether it's Muslims or other minorities, that Sharia law is going to overtake England, and there are people who, are going to change English law and they want everybody to be Muslim. Well, that's untrue. Well, yes, of course, there are extreme groups in every religion and non-religion. There are extreme right-wing groups, as we saw during Brexit and after Brexit, where sadly I also experienced discrimination, right, in restaurants, right? But my point is that's not representative of the whole of Muslims or the whole of the UK. So that's why I'm saying that this community evidence should be submitted to solicitors who are qualified to represent the asylum seeker in prepare the case, and that gets submitted to the barrister. The solicitors benefit from first-hand information from those originally from the country of persecution, and terminologies and cultural nuances are clarified for them. And I think this is very important, because when I've read Home Office refusal decisions, I would say, and I'm just giving a rough percentage here, I would say 40% of the time they do not understand the difference between, let's say, a Shia and Sunni Muslim, or they don't understand, for example, what leads to an honor killing. They may not understand the concept of murtad, which is being an apostate, right? And the ramifications if a Muslim changes his religion to a Christian, for example, or a Jew or whatever. And so then they say, well, what's the big deal? You can be removed to your country. But I mean, for those of you that are religious or a religion, changing one's religion is a huge action and carries with it a sin, or carries with it huge ramifications for this life and the next. And so, there may be legitimate reasons, by the way, for some people in Iraq to change religion because they see what ISIS has done, and sadly manipulated the fundamentals of religion to be something violent, which it is not. All right. So these nuances have to be understood, but they're not investigated to that degree. Whereas if this is clarified in a greater level, with a string of community statements saying, yes, this has happened to me, and this was my scenario, and I experienced this in my village, and this, and they explain this, and you see a chain of evidence developing. I think legally that would be hard to ignore, or at the minimum, it would at least clarify the experience of apostasy or the experience of divorce that the asylum seeker is going through. Not only that, it saves the solicitors and barristers time and money investigating these issues. They can focus on the asylum claim. We all know how legal aid has been cut significantly. We all know, especially due to COVID, the backlog of cases in courts. We all know the high cost of hiring solicitors. So this is also a money-saving exercise, right? Which I think any person would be interested in. And then the community evidence is included in the court bundle, and this helps prevent the judge from making errors of fact, which does occur, and interpretation of community laws and customs. He can focus on the law. The judge can focus on adjudicating the case. And so the community evidence is akin to referring to medical expertise. So as I teach issues in medical law, and as those of you that teach it or know about it, we have the Bolam test, right? Whether that's a good test or a cursed test sometimes, but the Bolam test is, well, as long as a procedure is actually approved by a responsible body of medically skilled men, then that procedure is valid, and that is not a negligent procedure, right? You have a responsible body of medically skilled men determining that procedure is a valid procedure. Well, why not use a similar approach in immigration and asylum cases? That you have a responsible body of, I don't know how to say this, linguistic, cultural experts, religious experts, that determine, well, this is the meaning of a term within Islam or in a Jewish community or Christian community, right? Or this is a legitimate experience, let's say, of being divorced. Because then what happens is you have a pool of specialist, reliable knowledge from experts in the field. So we do have a precedent for this, right? And then the community evidence can be translated into an online database to assist similar cases. As I've given the example, what is an Iraqi identity document and what meaning does it have in Iraq? Are Kurds discriminated in Iraq? I pose these questions. I don't want to repeat them, right? The database is managed by the community and becomes a resource like AIN. That's the electronic immigration network, which I'm part of. So it becomes a resource that then can be accessed by judges and lawyers. The database gives the community a legal voice and identity to express issues of concern to them, which are translated in the procedure and language of English courts, e.g. a witness statement. So you can use kind of similar terminologies to express the evidence. I've said witness statement, but I don't know, you can say community statements or community evidence, for example. So if this is, for example, some semblance of a procedure, right? Then, going back to my first slide, you can then produce cases. That's the next step, right? because then if you have community evidence, what the next step would be is if you have, asylum seeker X and Y and Z, then that can be recorded as a kind of case that, okay, this was submitted, or a hearing, at least a hearing, right? Sorry about that. And so what then happens is that this case itself, right, the judge can refer to and say, oh, in this Iraqi community or Indian or Afghani community, there was a case heard or a hearing which occurred, right? And so at the end of the day, we are able to refer to a string of cases. So it's not just statements, but there is a case where there's been a similar set of facts. This is how it was heard, and at least this was how it was determined by the community. The judge doesn't have to agree with that, by the way, but at least there is a semblance there of something they can refer to that, as I said, is extrinsic, right, beyond the immediate immigration system. Okay. Anna, should I conclude in a few minutes or take another 5 minutes? What do you think?
Feel free to finish. Yeah, we have 5 minutes. Yes.
All right. I think I'll go move towards the conclusion then. So, I had a number of other slides actually, but this just to show you that this, was also inspired from a verse of the Quran in Surah number 49, verse 13, where God states, Bismillah ar-Rahman ar-Rahim, Ya ayyuhan nasu inna khalaqnakum min dhakarin wa untha wa ja'alnakum shu'uban wa qaba'il لتعارفوا إن أكرمكم عند الله أتقاكم إن الله عليم خبير. O mankind, indeed we created you from a male and a female and made you nations and tribes that you may identify yourselves with one another. Indeed, the noblest of you in the sight of Allah or God is the most God-wary or God-conscious amongst you. Indeed, Allah is all-knowing, all-aware. And the Muslim mufassirin, or those people that interpret the Quran, the exegetes, they interpret this verse basically as saying that the verse was revealed to remove the arrogance of some of the Arabs at the time, that they claimed a sense of nobility or pride in their descent, that just because they were Arab, that the non-Arab were a second class, actually. And so what I am suggesting really on a moral level, I would say, on a spiritual level, on an ethical level, is to raise our moral and ethical awareness of each other, that there shouldn't be superiority in society, that our legal system, our notions of evidence and law, our notions of what we think of as a minority can always be improved. We can always recognize each other's identities, language, and culture more, right? I mean, I know the buzzword today is diversity and inclusion, and sometimes these buzzwords are hollow, right? But I am humbly trying to suggest a practical solution where I think not just the spirit of the Quran, but the spirit of a more inclusive society, which is also one of the objectives of CAJI, Center for Access of Justice and Inclusion, can be realized, right? This sense of greater identification and this sense of trying to see who is more worthy in the sight of God, who is more moral. I think that should be our objective, thereby removing superiority. And hopefully, I think, especially after Brexit, where we have seen, I think, a lot of maybe divisions and I think unnecessary discrimination against migrants and immigrants in society, maybe this is a possible solution to kind of change that. So thank you for listening, and God bless you all. I will stop there. Thank you.